Please, Your Worship. Richard Mpanga, Chief Secretary for persecution. All accused persons are in court. For accused senior counsel Martha will introduce the defense.
Please, Your Honor, my name is Karua, senior counsel, leading the defense, together with alias Lukwago, Mpanga, Apollo, Claudia Kunihira, Sekajo Mpanga, Sekajo. I'm pronouncing with a Kenyan accent. Eron Kiiza, Farouk Kamlager, Bayan Tulinawe, Kintu Michael, Kwagara Isaac, Katuswa Tobias. That is for the first and second accused. And for the third, Mr. Simon Subuga.
Next, please, George.
Our positive will gain the step being taken by the state before we make our application, which is outstanding since the last time we appeared here. And it's a command of the Constitution, it's a command of the MCA about the next step in any of the proceedings before you after the expiration of the 6th, the mandatory remand. So we wanted to proceed with our application, Your Worship, before any other step is taken.
Proceed.
Most of that, Your Worship. Your Worship, we pray that you be pleased to release A1 and A2 on bail in accordance with the provisions of Article 23 of the Constitution. My Lord, Your Worship, in clause 6 of Article 23 C, where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such conditions as the court considers reasonable. The operative word here, Your Worship, is shall be released on bail. That what gives this honorable court authority and mandate to invoke these powers to release the accused persons on bail. So, Your Worship, from the record, the accused persons have been on remand since the 20th day of November 2024, well beyond the mandatory period provided for under Article 23, clause 6, paragraph C. This particular provision is reinforced by section 76 of the Magistrates Courts Act, which reads as follows, if it may please you, Your Worship. If an accused person has been remanded in custody before his work trial commences, in respect of an offense punishable by death, for a continuous period exceeding 180 days. B, in respect of any other offense, for a continuous period exceeding 60 days. The magistrate, before whom the accused person first appears after the expiration of the relevant period, shall be released, so the magistrate before whom a person first appears after the expiration of the relevant period shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in section 75, unless one, he or she has, prior to the expiration of that period, been committed to the High Court for trial. Now, Your Worship, from the record, the accused persons have spent over 180 days. That's a fact which is not controverted. And it's also well canvassed in the affidavit of Koinihira Roscovia, which we filed on record, to bring out the history of this matter and the chronology of the events, right from the time the accused persons were kidnapped from Nairobi on 16th of November and taken through the processes before the General Court Martial on the 20th day of the same month, November 2024, and remanded to Zira, where they have been languishing up to the present moment. All those particulars, those facts are borne out in that affidavit, are brought out in that affidavit, which is not rebutted in any way or controverted. Your Worship, on record, on the 31st day of January, the Supreme Court directed the General Court Martial to cease any trial of civilian cases, and that all those matters be transferred to the ordinary court, to the conventional courts, the courts of judicature. And that is the genesis of this matter. And that's the reason we are here. So that is in the chain of the events, right from the time of kidnap to formal charging or indictment, and then subsequently remand, and up to the present moment. So now, Your Worship, here, there are two things we need to emphasize here. After blocking 180 days on remand, two things here are fundamental. Number one, this magistrate court cannot take any other step save for handling the proceedings relating to the release of the accused. No any other step. This honorable court cannot in any way proceed with issues to do with the amendment of the charge sheet or any other action be taken except to issue an order of release on such conditions court may deem appropriate. That is number one. The second one, have they been committed before the expiration of the 180 days? The answer is no. And this is the spirit and letter of section 76, paragraph B1. Unless he or she has, prior to the expiration of that period, been committed to the High Court for trial, prior to the committal. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't host the jurisdiction of this honorable court from going ahead with the mandatory plea. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of the would like to ask this honorable court, Your Worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was coached this way in section 76. Why this particular provision was coached that? To stamp out persecution, impunity. It was intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution will arrive to that fact that the state may exceed what is actually within the limit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit, the reason there was that limit of 180 days, and the court was given those powers that once the state has failed to take steps to commit their chosen persons within 180 days, first appearance before you as a magistrate, don't do any other thing. Please, just consider releasing their chosen persons. And that's what we are asking for, Your Worship. This honorable court should end up with or be an accomplice in the persecution of their chosen person by the state. So the only thing that should be done at this stage is to release their chosen person. So
what the court ought to satisfy itself is that the offense is triable only by the High Court. And that the person who is the applicant has been on remand for more than 180 days before committing. So I join issue with my senior colleague, Mr. Lukwago, that the committee per se does not take back time to nullify the 180 days. The 180 days are constant. 2, Your Worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made. I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application is made. I'm mindful of the decision of the Supreme Court. The Supreme Court directed a transfer of the files. What I'm trying to say, Your Worship, is that the process from the court-martial to this court is continuous. There is no break so that the proceedings before the Court of Appeal, before the court-martial, are not taken into consideration. So when we speak to the 180 days, Your Worship, the court must take into consideration the date of remand by the General Court Martial, because it is also a court under the Constitution. So that article, Your Worship, again for emphasis, says in case a person has been remanded in custody. It doesn't say, it envisages that a remand shall be made by any court of law, or any court as established by law, or with the general court martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year, and therefore they are not 180 days, does not hold. Court takes into consideration the time when the remand started to run, count the 180 days. And Your Worship, there is a view that perhaps in matters or offenses tried only by the High Court, the Magistrates Court should not grant bail because the matter is tried by the High Court only. Your Worship, in the current constitutional dispensation, the Magistrates Court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Tesimana Rosemary, the Honorable Mr. Justice FMS Egonantede, as he then was, Tesimana Rosemary, its criminal revision cause number MSK -00 CR CV -0013 of 1999. I cite it because it is the current dispensation. Because in that case, again, Your Worship, the magistrate had declined to exercise powers and sent the file up for revision on the ground that the matter was tried by the High Court. Your Worship, I beg to read, and I have read a copy, what the Honorable Justice Egonantede said. I wrote, this is the, Your Worship, it's the highlight at page 13. So before I take leave of this case, I must say that courts cannot escape the blame for this unhappy state of affairs in the criminal justice system, which has no remorse for caging up people in penal institutions for unjustifiable periods of time. It appears that magistrates courts to which accused persons are first produced before committal regard themselves as no more than, should not regard themselves as no more than assembly line or conveyor belts run by the prosecution. For years on end, the court is content to record endlessly adjournments, etc. But the point, my lord, the judge said at paragraph 39, that even though a magistrate's court has no jurisdiction to try capital offenses, accused persons such charges are brought before it to ensure that, among other things, the accused rights are protected. The courts must be vigilant in doing so by consistently requiring the prosecution to provide information regarding the investigation. What we are pointing out here, that the constitutional command says that once the accused person is emphasizing their rights. Once the matter is before it, even for capital offenses, this court cannot fail not to have jurisdiction on the ground that the offense is of a capital nature. In Article 23C, therefore, the accused persons contend that they have been on remand by order of the court so established under the Constitution, the GCA, for a period exceeding 180 days. If I count well, Your Worship, today there should be 196 or thereabout.
Remand and custody was 20th November 2024. Filed General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. The state is aware of this fact because they have said so in an affidavit before this honorable court. The state, through its detective IP or Diego Benedict, they acknowledge that the respondents, namely the accused, were previously charged before the General Court Martial at Machinde. The application was filed on 5th March 2025, and it is the application for accessing the court records. Yes, the telephone particulars, which your honor is on this honorable court's record.
I think Your Worship, maybe just to interject a bit, allow me something.
I have not said the word and you're panicking.
Just make that.
Yes, you can't stop me before I say the thing. Relax.
I hope you don't forget another one.
No, it's fine. Don't
So
mistake.
what I'm saying is that the document which Managed Brother is referring has not been accepted. And therefore, it cannot form part of the record. We cannot preempt a document in an application which has not been had and you use it as evidence in your application.
Let him finish his submission.
Your honor, before I was rudely interrupted by the representative of the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001/2025, in which the number 01/2025, in which the state made reliance the affidavit of detective IP of Diego Benedict, who saw that is aware not only that they are chosen were charged before the General Court Martial, but that is also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your Honor, the plea for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial and detention is not too lengthy. Your duty as this honorable court is partly adumbrated by Article 20 of the Constitution. Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is to the effect that this court, the office of the Director of Public Prosecution, and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of Besigye, Beard, and Dennis. It should not be seen as to frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it behoves you as the judicial officer presiding over this matter under that article to rein in the state and put and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, Clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months should be seen as inconsequential to the extent of that. And I say this in anticipation of some speech that may come after here relating to some practice directions, which are in fact a challenge of the are being challenged before the Constitutional Court. But even those guidelines themselves acknowledge that the Constitution comes first. At this juncture, my lance brother who wanted to give us an authority should give us, then our closure will come through.
Most obliged, Your Worship. Your Worship, for purposes of record, client will know. Your Worship, I want to join issue with my learned brothers who have submitted on the hours of this court to grant accused persons mandatory bail, but only in part and authority. For when court takes a view that the authority that was submitted is of an earlier date. Your Worship, I have much of that. For if court takes a view that the authority that was submitted is of an earlier date, Your Worship, formally in 2022, the Honorable Justice Biaruhanga Jesse, sitting at Masini in the High Court, in Nyangoma Flavia versus Uganda, Nyangoma Flavia versus Uganda, in criminal application number 7 of 2022, at page 3, paragraph 4, had the opportunity to say this, and I will quote in verbatim. I have perused the lower court file copies of the lower court copies of the remand warrants and the applicants and 7 others. The remand warrants are to the effect that the accused persons were remanded first in prison on 12 November 2021, save for Kato Francis, A8, who was released on bail on account of being a juvenile. Since 12 November 2021, when the applicant and the 7 others were first remanded to prison, more than 180 days passed before the committal to the High Court. It follows, therefore, that neither the magistrate's court nor the court that has neither the magistrate's court nor this court has any discretion not to grant them bail. It was a violation of Article 23, Clause 6, Subclause C of the Constitution as amended for the magistrate before whom the accused persons first appeared after the expiration of the 180 days remand period to decline or refuse to release the accused persons on bail, for he or she had no discretion to do so. Your Worship, if I may add, is that such a decision of the High Court has a binding authority nature on this specific court.